Good morning, everyone. Welcome to the fourth video in my series of shorts on the contracts and things that you need to understand in your real estate practice. Today, we're talking about inspections under the FARBAR contract. My name is Sam Saad, and I am an attorney here in Southwest Florida. Because I'm an attorney, we're going to start off with a disclaimer, providing you advice, but it is not necessarily legal advice you can rely on for your own purposes. A little bit about me. I have been practicing law for over 20 years. I have a law firm in Southwest Florida that is dedicated to helping realtors, small business owners, buyers, sellers, property managers manage their real estate practice and their business. I serve on the committee that drafts both the Naples Area Board of Realtors and the Florida FARBAR contracts. So I know these forms very well, and I'm happy to take your questions at any time. For your closing services, we do have a title company, Paradise Coast Title and Escrow, and you can reach out to me on my cell phone number here on the screen anytime. Most importantly about Paradise Coast Title is the service we provide our realtors. And I like to keep these presentations short, so we're going to dive right into the inspection period of the FARBAR contract. Let me just start off by saying we're talking about version 7 of the FARBAR contract. It's the newest version for 2025. And we're talking about section 12 of the general contract, not the as-is contract. So we're talking about property inspections and repairs. And let's just dive right in. So under the FARBAR contract, the default is a 15-day inspection period where the buyer can conduct inspections at their own expense. If they do not complete the inspections during the inspection period and give notice to the seller of the defects they want repaired, then the buyer is deemed to have waived their repair requests, and the seller does not have to make any repairs. This is pretty important because the repairs that are allowed on this contract are fairly comprehensive. You get 3 inspections under this contract. You get the general inspection, the wood destroying organism inspection, and the permit inspection. We're going to go through these and talk about how to conduct them under the contract terms, which can be a little bit cumbersome. But if you want a deal that's going to be kept together by the contract and not have outs, this is a big difference from the NABOR contract, for example, where the seller has no obligation to make repairs. Under this contract, the seller must make repairs up to the repair limits, and we'll talk about those. So what are the general inspections? A few thoughts about those. First of all, they must be completed by a licensed inspector. The contract calls a professional inspector. And you can use a general contractor or a home inspector, but it must be licensed to conduct the repairs that are going to be asked for. And the buyer must deliver the reports evidencing the items to be remediated. They don't need to deliver the entire report, but at least the portion of the report that they want the seller to fix. So what can the buyer ask for? Well, under the general inspection items of section 12, you have 3 things that they talk about here. First of all, there's the property must be free of leaks, water damage, structural damage. That pertains to the ceilings, the roofs, the walls, the windows, the foundation. Things that must be in quote unquote working condition. That's the pool, the major appliances, the heating, cooling, mechanical things in the property, dock lifts, things like that. Interesting thing about this contract, the seller must replace or repair torn screens, fogged windows, and missing roof tiles and shingles. So if you saw number 3 in my series on the NABOR contract, you'll know this is a big difference. These items are considered cosmetic under that contract, whereas under FARBAR, the seller would be obligated to, for example, replace missing roof tiles or shingles, repair fogged windows, which generally means replace them, including things like torn screens. Note that sellers are not obligated to repair cosmetic conditions. Those are aesthetic imperfections that do not affect the working condition of the property. So, for example, worn or discolored carpeting or wallpaper, window treatments, nail holes, scratches or scrapes in walls or ceilings, and minor cracks. And I mentioned this in the other presentation, but what is a minor crack? I've heard realtors say, if it's more than half an inch, or if I can fit a nickel in there, then it's a major crack. And I said, well, I think you have to look overall at the totality of the circumstances for major versus minor cracks. If it's a structural issue, like it's a giant crack running up the wall of the garage, which is a case that I've had, then you probably have a major crack. But if it's a few minor spider cracks in the driveway, probably minor. So those, details like that you have to fight about in this contract. So the structure must be free of leaks, water damage, structural damage. The major systems must be in working condition. The seller does not have to repair the cosmetic items. Talked about that. If you're the seller and you want to dispute inspection results, this is where it gets a little bit hairy. And I printed the contract just in case anyone has any questions about this particular portion. We have to go through it in detail, but basically I want to give you the high level. The seller, within 10 days of receiving the reports, can have their own inspections done. They give those reports back to the buyer. If the buyer's estimates and the seller's estimates don't match, then they can't agree, they can get a third inspector to give a report, and that's going to be binding on both sides. Up next, talking about wood destroying organisms. You need a licensed pest control business to do the inspection. They're looking to determine if there are any past or present WDO infestations or damage. If there was a previously treated infestation, the seller can transfer the warranty and the seller doesn't have to do additional work. If there's a live infestation found, the seller has 10 days to get an estimate for repairs and provide the copies to the buyer, and the seller is required to pay for treatment repairs up to the WDO limit. And I'm going to talk about these limits in a minute when I show you the contract terms. But the seller is only obligated to make repairs up to certain limits. So these are not unlimited obligations like the NABOR contract. I'll tell you on the WDO inspection, the buyer has 5 days to give notice to the seller that the buyer will either pay the excess if the repairs exceed the WDO limit. They can designate which repairs the seller shall make and accept the remaining property as is. If the buyer does not give notice to the seller within 5 days, then either party can terminate and the buyer gets their deposit back. So that's an interesting way to handle, you will say, competing WDO claims. For open permits, the buyer has to notify the seller in writing of any open or expired permits or unpermitted improvements. Those are two different things. The seller must deliver to the buyer all documents related to any open permits or unpermitted improvements. And then the seller has 10 days after receipt of the notice to figure out the costs and deliver to the buyer an estimated cost to remedy the issues. The seller has until 5 days before closing to deliver the closed out permits to the buyer, documentation of the closed out permits to the buyer. This can be very interesting because you could be coming up to the closing date. If you are within 5 days of the closing date and you've not resolved the permits, then you've got to go through the process of possibly extending for final inspections. So you can have an extension of the closing date for open permits under this contract. That's very different from other contracts, which provide for an escrow. And if the cost to close or remedy the permits exceeds the permit limit, then the parties have 5 days to either have the seller pay the excess, the buyer can take the property as is and receive a credit for the permit limit. Or if neither party delivers the notice, then the parties can terminate, the buyer gets their deposit back. So let's talk about the permit limits. You've heard me say the limit for WDO, the repair limit, and the permit limit. The cost of the repairs for each inspection is by default capped at 1.5% unless the parties negotiate a different percentage or a dollar amount. And if the seller does not complete the required repairs, then we escrow 125% of the estimated costs up to the limit caps at closing. Let's take a look at the contract so you can see what these limits look like. So this is section 9 A, I believe. Wait, let me look. Make sure I give you the right section. Yes, 9A. The seller shall pay the following amounts of the purchase price for the following costs and expenses. Then you can see that the general repair, you put a dollar amount or a percentage. You've got your WDO treatment, you put a dollar amount or a percentage, and your open permits a dollar amount or a percentage. Notice the defaults here. I want everyone to notice this. If you leave this blank, you're obligating your seller up to 4.5% of the purchase price for repairs, potential for repairs. That is, in my opinion, a lot of money if on a larger property to have out there for repairs. On $1 million property, that's $45,000 for repairs. Sellers don't like that. So think about when you're filling out your contract and the purchase price, how much these repairs are going to potentially be. For example, if the tenting of a house is a couple $1,000 and you leave it at 1.5%, that's $15,000 on $1 million property. Is it really going to be that much to get WDO repairs? And is the seller going to want to be obligated for $15,000 of WDO repairs, depending on the property? So again, talking about if prior to closing the seller cannot get the repairs done, then you escrow 125% of the cost, not in excess of these limitations up here. So,
Sam?
Yes, ma'am.
This is Kathy He. Good morning.
Morning,
So,
Kathy.
Sam, so this is your purchase and sale agreement. So we don't have the inspection report back. So what do you recommend that we put here?
So that's a great question. You won't have the inspection report to know how much. You have to figure out. That's why they do it as percentage. What is the seller really willing to risk in terms of estimated cost? What are they willing to give up for repair items, should any repair items come up? As we know, all sellers think their house is perfect and it doesn't need any repairs. So they're going to want to put as little at risk as possible. Buyers, of course, see everything is wrong, especially when they bring their father-in-law along to the inspections. And they want as much as possible. So you're going to have to negotiate this without the benefit of knowing what the actual costs are going to be. So if you put too small an amount, or if it's, a $200,000 property and 1.5% is $3,000, but you know the property needs to be tented because of the termites, then you might put a dollar amount in this blank here where I've got my mouse, so that the seller knows, listen, it's going to be $5,000 for the tent for my $200,000 house. It's a great question, but there's not an easy answer. Other questions on this?
But if I understand you correctly, because this is being presented through the buyer's broker, buyer's agent, the numbers are somewhat arbitrary because until
Very arbitrary,
right.
Yes.
So this can be then under the attorney's. I'm assuming we're going to have an attorney's approval attached here. At least I would. That would then be negotiated further, not through the realtors, but through the attorneys as to the actual amount. Correct? Or would the realtors do that?
Normally the realtors would negotiate this and get the contract signed and turn it over to the attorney. If you did have an attorney review period and we looked at the property, we would say, this is probably a little bit much if I've got the seller, or can we get a little bit more if I've got the buyer?
Right.
I think that's an area to negotiate, but who was it? Kathy was saying, yes, you are not going to know what's going on. So if your seller comes in and says, I'll give you $500 for repairs and not a dollar more, and the buyer agrees, you put $500 in this blank here where my mouse is, and
Yeah.
then it comes out that it needs a new roof, or the roof is leaking massively and it's $10,000, then you probably are going to be terminating. And what you come up with is the seller now knows their roof is massively leaking and they're going to have to disclose something under Johnson v. Davis. So there is an incentive, I guess, for the seller a little bit to get their have accurate get the deal done, because they don't want to go back. They don't want to go back and have to tell people that there's problems.
Yeah.
But again, you are not going to know what the real issues are until you complete inspections. Michael, you
So
mentioned. Go ahead, Marsha.
following up on that, so can I simply just, once we come to an agreed amount, if it has to be negotiated, can we just simply cross out? So if in the first one, originally we wrote in $1,000 and it ends up getting settled at $750. Can we just do a cross out and initialing on that, or do we have to add an addendum?
Are you talking about in the negotiation process before
For
it's
the
signed?
actual contract, so that, I personally, if you can, make mark it up and get initials from all parties, is that?
That's always the
acceptable?
best version, the best way,
Yeah,
if you keep it neat and
yeah,
negotiate the purchase price and the deposits and the repair amounts.
right,
You keep it neat. It's probably better to cross out an initial so you don't have to do a
yeah,
new form and risk changing the effective date or anything.
okay,
That's probably the
thank
better
you.
way to do it. And then Michael, you asked a couple of questions. Do they have the right but not the obligation to get the third inspection? Um, Michael, that is a great question. I would say they have the option. The contract is not 100% clear on that. And then Michael, you also mentioned up to 4.5%. If all left blank, am I correct that each one is still capped at 1.5? So for instance, if one is over 2%, then the cap is still 1.5. So you cannot borrow from one to the other. That's exactly right, Michael. So if the property has open permits and it's going to be like 3% to get the permits closed, and you have no repairs, for example, you don't get to borrow from one to the other. It's for each individual category. So for those of you that can see the chat where Michael is asking, he's asking if you can borrow from one to the other, and you cannot. They're separate buckets. Think of them as separate silos of money.
Sam, could you clarify for me, if you put a percentage in there, let's say it's either any of the three categories, you put 1.5%, but the actual cost is less than that. Are you obligated, or sorry, the seller obligated for the full 1.5%, or
No, you
Okay.
only pay for actual costs up to the limit. The limit is
Okay.
the max, not the minimum.
Okay,
And then
great.
Chris, you were asking about the lines of these on the contract. I'm using the Florida Realtors 7 version, and the lines are 143 to 148 in the FARBAR contract. It's section 9A, closing costs, fees, and charges.
So Sam, to protect the buyer, shouldn't you just put 1.5% or more?
Or more if you have the buyer. Yeah, you'd want 1.5% or more.
Thank you.
But again, you got to be reasonable if you want your offer accepted. If it's a new house and it's got the WDO treatment in the ground and all the stuff they do in new houses to prevent termite infestations, do you really want to go in there at 3% for WDO treatments, even if it's a smaller property, and just have the seller say, you know what, I'm not going to accept that. So yeah, there's going to be a negotiation for all of these points, all three of these. Okay. Jessica's asking, can you put more? Yes, you can. You can put whatever you want. It's a free negotiation between the parties. Okay. Other questions on this? All right, let's do the next slide. I want to talk about one more repair.
Oh, I'm
So
sorry, could you go back? And I think Jessica was trying to convey, she wanted to know, someone had said 1.5 or more. Can you actually write in that blank 1.5 or more? Because
no,
that's an open-ended, isn't that becomes
no, no, you
avoidable
cannot do that.
contract, right?
You put a fixed number in there.
Right. So no or more.
1.5%,
Yeah.
2%, or in these over here, $1,000, $5,000, $10,000, whatever it is. You would not
Thank you.
put or more. No, no, you would
Thank
not
you.
do that. These are limitations, not minimums. So FARBAR is interesting in that NABOR has 6 inspections and FARBAR has 3 inspections, but FARBAR gives you the option on an addendum I for mold inspections. And this is an interesting way that they handle it. Basically, you get 20 days, unless you negotiate a different amount of time, to do a mold inspection, determine the presence of mold and related damage. If the mold inspection reveals the presence of mold that requires remediation or repair at a cost that exceeds, and you put a number in this blank, then the buyer can cancel the contract. I always find this interesting. There's nothing that for mold that gets done for $500. So you're going to put a bigger number in this blank if you use the mold inspection. But the interesting thing is with this contract does not accept allergenic molds. So if you found Penicillium aspergillus or allergenic molds, the seller would be obligated to make those, or not obligated, but the buyer would have an out if they found those molds that are found in every property. So be careful in accepting an offer with this mold inspection, because even if there are allergenic molds, which again are in every property, then you are going to have an out for your buyer. Last thing I'll mention is there aren't really any forms for FARBAR. Florida Realtors does provide an amendment form, a blank form that you can fill in with lines on it, but they don't really provide notice forms and things like you get under the NABOR file, under the NABOR contracts. And I'm not saying NABOR is better than FARBAR. Every contract, I should mention this in every video, every contract, is a tool. So you may need this type of inspection in this contract, or you may need that type of financing in another contract. And so I don't want to say FARBAR or NABOR or any of the other forms around are better, but FARBAR does not provide forms that you can easily fill out. So you need carefully worded email telling the other side, my buyer is electing to have the seller repair, list the repairs, they're under the repair limit, please get them done in a timely manner for closing, things like that. And you may need an attorney to draft amendments to the contract. And with that, that is FARBAR inspections in a nutshell. Again, I try to keep these videos in this series shorter, but I will take questions. So if anyone has questions about the FARBAR, really any other real estate issue, please unmute yourself or type them in the chat.
Hey, Sam, you covered this greatly, but are there any real slip-ups that in representing a buyer or a seller that we really should focus on?
Well, I tell you, this contract is not widely used across the state of Florida. I think the stats are something like 90 or 95% of the contracts are written on the FARBAR as is, and like 1% or 2% are written on this contract. So it's not widely used. And the reason for that is if you read section 12 carefully, it's a pain in the rear. It is difficult to administer. You have to do your inspections. You have to give notice to the seller. The seller has to give notice back to the buyer. If you don't, if you have the cost of the repairs exceed the general repair limit, then you have notices that go back and forth between the parties. If you do not do the proper notices in the time frame, then either party can terminate. So it's a cumbersome contract. I'm in Naples, and we use the NABOR contract a lot down here. we really don't see this contract much, but it's getting more and more usage. So you might see it as other people move to this area, but really it's a cumbersome contract and you need to read it carefully and make sure you have a really good calendar and timeline of your events. So that's what I would say as a practice tip for the FARBAR regular contract. Penny? Oh, okay.
Sam,
Other questions?
did you send out your slides from the previous ones yet?
I'm not sure if we've got all those out yet. I have a lot of slides now, so we're managing that process and posting the videos to YouTube. I can get the slides out to anyone who needs them quickly though. So if you shoot me an email, I'll get them to you.
Okay, thank you.
Yep. Other questions?
What's your YouTube?
Oh, YouTube, just Saad III.
Saad III.
Saad III. Yep, that's a good question. It's pretty much my handle for everything. Other questions or anything? I don't want to take up too much time in these morning sessions, but if you do have questions, you can always call, text, or email anytime you want. Happy to take your calls and talk to you about these issues. With that,
Okay.
unless there's any other questions, I'm going to say thank you.
Wait, I have one question.
Oh,
You
sure,
were
go ahead.
talking, what was the, because I'm looking at the revised 325 of the contract, and I did not find anything that you were talking about on there.
Where are you at?
The contract for residential sale and purchase, the FARBAR, right?
Yeah.
And it says revised 325. But what you showed on the screen, I do not see on this contract anywhere.
Well, I think you're looking at an older version. Unless I'm
Oh, there's newer one than
unless there's a newer one.
325?
Well, I'll have to look and see which one you're looking at because I pulled mine off the Florida Bar website for the Florida reptile section of the Florida Bar. If you got yours on a Form Simplicity, it may be a little bit different.
Okay, yeah, that's
The
where I
section,
did.
if you look in section 9 of the regular FARBAR contract, you should see what I was showing on the screen.
Yeah, and it's not exactly what you showed. So that's why I'm like, I must not have the newest version. This says 325.
I'll have to, Penny, shoot me an email. Let me look at it. Maybe I need to update my version.
Okay.
I'm not sure.
Because I couldn't find anything you were saying. I'm like, what contract am I in?
FARBAR regular contract, not the as is.
Yeah, I'm in the regular one and I did not see anything about percentage. In fact, it's not in this contract at all.
All right, send me an email. Let me look at it.
Okay, sounds good. Thank you. And did you say at the beginning you had 2 other ones before Tuesday? Because I missed those 2. I thought it started
I did how to fill out the FARBAR and NABOR contracts on last week. So
okay, I'll add that if you can send those slides because I missed that.
those do not have slides. Those were screen shares of Form Simplicity.
Okay. All right.
So, okay, I'm sorry to jump in on this. So are those 2 on your YouTube channel? Because
Yes.
I'd love to see those as well.
Everything is either on or will be on YouTube shortly.
Oh, you're awesome. Thank you so much. Have a great day.
Thank you, everybody. All right. Talk to you all soon.